phone number that ends in 8883. Can you please unmute your device and tell us your first and last name? It's star 6 to unmute. Hit star and 6 to unmute the device. 8883. Please hit star 6 to unmute your device. We can't call your case if we don't know who you are.
Hello?
Yes, please tell me your first and last name.
Well, my name is Benjamin Meyer, M-E-Y-E-R, unlike the paperwork that I've been sent. But it says M-Y-E-R. It is not me. I am here under duress.
Mr. Meyer?
Yes, ma'am. M-E-Y-E-R, not the person you have spelled on this paper.
Mr. Meyer, please stop talking.
Yes.
The court will call the case of the State of Michigan versus Benjamin Meyer, case number DIB 053809. Is that correct?
See what's for the people.
267659. Thank you. Mr. Meyer, you've placed your name on the record a number of times at this point. You're here for a contempt hearing today. Mr. Meyer, you owe this court $168. When do you plan to pay it?
I do not plan to pay it because I don't own it. Period. End of discussion.
Okay. Well, then what I'm going to do, Mr. Meyer, is find you in contempt of court.
And what you're going to do is find yourself in a 1984 federal lawsuit.
All right. Let's do it however you want to do it. You're found in contempt. You need to be here in person.
Absolutely not. I will not be coming to your court for any fucking reason.
Bench warrant to issue.
And what you're going to do is find a gunfight and a fight on the side of the fucking road.
All right.
This fine and fee was paid 10 years ago or more. Now you can either fucking listen or we can do this out in front of your court.
Mr.
This fine was paid 10 years ago. Will not be paid again. You fucking damn near shot me and killed me. Are you fucking kidding me? Have you goddamn lost your fucking minds?
30 days in the Washtenaw County Jail. Keep it up. We'll go with more.
And we'll see you hung in front of Washtenaw County Jail.
All right. Threats. I'm going to report that to the Attorney General.
I'm reporting you to the fucking Attorney General. Are you fucking nuts?
Okay. Everything you're saying is being recorded.
You are a goddamn tyrant.
All right.
I called the goddamn fucking attorney's office and you fuckers rejected me. Are you insane?
3 days in the Washtenaw County Jail. Keep it up.
Oh, you'll find yourself in prison, bitch.
All right.
You think you're a goddamn king? You're a fucking tyrant.
90 days in the Washtenaw County Jail.
Below me, bitch.
All right.
Before we even get into today's courtroom chaos, buckle up, because this video is a 3-course meal of unhinged behavior, sovereign citizen nonsense, and the kind of self-inflicted legal disasters that make judges question their life choices. We're starting with a contempt hearing that goes completely off the rails, not with legal arguments, not with facts, but with profanity, threats, and a man who thinks yelling louder somehow makes him right. And when I say threats, I mean the kind that take you from contempt of court straight into consequences you absolutely cannot undo. Then, because the universe clearly wasn't done, we head into Judge Bruni's courtroom, where another sovereign citizen confidently announces he doesn't owe child support because he never contracted with the court. Spoiler alert, biology is the contract. From there, we get constitutional buzzwords fired off like a machine gun, Title 4D misunderstandings, and one of the most unintentionally hilarious exchanges about privacy you'll ever hear in a family court setting. And just when you think logic might finally make an appearance, We cap things off with a formal traffic
just to
hearing
let
where
you
dashcam
know,
footage does what sovereign arguments never
Mr.
can.
Smith,
It tells the truth.
it's the
This
middle of
video
page
is a
1.
masterclass in how
He
refusing to
does not want to
understand the
deal
law
with me
doesn't
because
exempt
he
you
does
from
not
it.
have a
Let's
contract
get
with
into it.
4D, with any 4D workers, so he doesn't want really to talk to me. He wouldn't talk about the motion, so I'm going to submit a recommendation that the motion be denied.
Okay.
Okay,
It's not
he's very
really
difficult. I know that you read through all the paperwork. He is the individual that was talking about how he has continued to talk about that he's, he has all these constitutional rights, and he's I don't know. I can't even explain what it is he's trying to get to or what he's trying to talk about. So
Okay.
okay, so there's not much I can do. He just basically told me that I'm not someone that he's willing to talk to because he doesn't have a
Okay.
contract with me.
He maybe doesn't want to talk with me either, but you can get Sarah, you can bring him in. And
I can get
address
him.
that.
Yeah, and I'm in the process of sending you the recommendation that the motion is denied, but I can go and get him and bring him in.
Thank you. Thank you.
Thanks.
A motion of the defendant, Father David Smith Jr., to modify custody and parenting time. This hearing is being conducted via Zoom. Present is Sherry Zorn, as well as David Smith Jr. Mr. Smith, it is now 9 o'clock and you are before Judge Brownick. Good morning.
Sir, I can barely hear you. I was in my vehicle where I could, and fortunately, we're back in front of Title 40 incentivization. If you can give me a second so I can make it back out to my vehicle so I can hear you, I would appreciate it.
Okay. Do you want to zoom back in then?
I'm parked right outside the door. Give me 60 seconds. I had to come back inside because whatever just went on.
Mr. Smith, your current parenting time is alternating weekends, Friday at 5 till Sunday at 7 with your 2 children. Is that correct?
Yeah, but we work outside of the order. I mean, I got numerous evidence that we do work outside of the order. That was arbitrarily done to maximize the dollar amount pursuant to Title 4D.
Well, that's wonderful that you can both be flexible about parenting time with your work schedules and the children. That's once we work together. I'm just noting that the last order of the court, August 2015, so I do review these files in advance. I review your motions. I review the past orders. I review the history of the case, Mr. Smith. I
appreciate that.
So I'm just noting that the last order gave you specific parenting time, alternate weekends, Fridays at 5 to 7 at 7, Sunday at 7, and you could have additional parenting time, but that's your absolute minimum. Now, in your motion, you're asking for an 80-20 split pursuant to your 14th Amendment to the U.S. Constitution. I don't know, this is not a constitutional issue. It's a state law issue, Mr. Smith. And in order for, first of all, have you talked with Ms. Zorn this morning? Do the two of you have an agreement? Certainly, if you have an agreement, you know what's best for your 2 children.
Sir.
We do not.
Okay. So, is there any merit in talking, Ms. Zorn and Mr. Smith?
I object. I made my kids in private. I'll raise them in.
This is the exact moment where everything crosses from defendant being difficult into actively making things worse with every sentence. Notice what's happening here. The judge is still offering off-ramps, ways to de-escalate, ways to resolve the issue, ways to keep this from spiraling. And instead, the defendant chooses threats, profanity, and personal attacks. That's not protected speech in a courtroom. That's contempt stacked on top of contempt. And here's the part people like this never understand. Courts don't argue back. They document. Every word he's saying is being recorded, transcribed, preserved, and potentially forwarded to prosecutors. Threatening a judge isn't hyperbole. It's a crime. The sentence increases we're hearing aren't emotional reactions. They're procedural consequences.
My kid, this is
Judges
a
don't get
case.
offended.
Am I
They respond to conduct.
At this time
And
with
this
all my
conduct is a
constitutional
textbook
rights in
example
full
of how
force
to
and
turn a
effect,
minor
sir?
issue into jail time with absolutely
You're
no
innocent,
help from
but
anyone
there's
else.
no criminal charges here, so I'm not sure what you're innocent of.
But-
Mr. Smith, no one's accusing you of anything. I'm just asking, normally the two parents will talk, and maybe they come to their own agreement. But that apparently is
I
not to
want
be possible this
50-50.
morning.
This is a
So you're asking
non-TANF
for-
case getting treated as a TANF matter. I want split custody, mutual agreement, all Title 4D indemnification cease and desist immediately. I will be sending letters out today to all parties that touch this case negatively, and I'm pursuing charges 42 U.S.C. 1983 and Article 3 corporate deprivation of rights. This is arbitrarily done underneath color law. I do not consent. I have not contracted with Title 4D. I would submit into the court's blessing versus Freestone, Wehunt versus Ledbetter, sir. I don't presume ignorance on the court behalf today, therefore I'm left to believe something much more sinister is going on here.
Right, Mr. Smith, it's not a constitution, under state law, Michigan law, there
I
must
do not
be.
acquiesce to state law, sir. I operate on federal law only. This
Okay.
is impeding my rights. I am going to transfer to Article 3 court and pursue. I'm going to file emergency injunction if I can't even make my bills. Due process has been violated. Fair Creditors Act of 1970, you guys are taking well over half of my check. I can't even make my bill. This forces me into my 13th Amendment, which is enslavement. Pursuant to no lawful money, this is a bill of pen and penalty underneath Article 1, Section 16 of the Constitution, sir. I do not consent. I do not consent. I have not consented.
And with that explosion finally out of the way, we shift gears, but not into calmer waters. Because now we're entering the sovereign citizen favored genre. Child support denial disguised as constitutional theory. This is where legal jargon gets weaponized, not to make an argument but to avoid responsibility. The moment someone starts talking about contracts instead of children, you already know where this is going. What's especially important here is that Judge Bruni and court staff are doing exactly what they're supposed to do. Giving him an opportunity to be heard, explaining procedure, and trying to figure out what the actual motion is. But sovereign ideology doesn't care about clarity. It thrives on confusion. And as you'll see, the more the court tries to ground this in reality, the harder Mr. Smith leans into buzzwords, misapplied amendments, and imaginary legal loopholes that exist only on internet forums.
Your position is duly noted for the record, Mr. Smith. Mr. Smith,
Thank you.
under Michigan law, which this court is bound to follow, there must be a change of circumstances that would
Must
support
be
a
an
modification of custody and parenting time. In your motion, you've not alleged any change of circumstances that would warrant a review of custody and parenting time. So with all due respect, the court at this time will deny
Sir,
your motion to change custody and or
I
parenting time.
have the right to my privacy. I can't even make my bills with what you guys have done here today. I can't, honestly, I have proof. I would like to submit into the court's Exhibit A if there is no objection. I have a pay stub right here. I work 58 hours a week at $30 an hour. I come home with less than $300. I can't even make my bills.
That's an issue of child support, Mr. Smith. You're asking to modify
Sir,
custody and parenting time today.
I am
If you
not
want to file
here.
a
I'm
motion to
here
modify
to cease
support,
and exist.
you should
All
file such a
Title
motion.
4D. Sir, do you have a contract in dispute with me? I'm asking the court, Ms. Zorn, to place into the court all evidence she has partied on my contract. If not, I motion to dismiss with prejudice, failure to state a cause of action. This goes against my Constitution, sir. Yeah, I understand Michigan law, but it must be in compliance with the Constitution. This has violated me as a man numerous times, and now I can't even make my bill. I'm asking you to give me 50-50 split of my kids. I made them in private. I will raise them in private. There is no need in dispute, nor has there ever been. You know what, sir, underneath Article 1, Section 13, Paragraph 5, I want to face my accuser. If we could please swear Ms. Zorn in so I could face my accuser here today, sir, I would appreciate it.
This is one of those moments where the courtroom collectively pauses and tries to figure out how a sentence like that even escaped someone's mouth. I made my kids in private, so I'll raise them in private. Sounds clever until you think about it for more than half a second. Parenting isn't a private transaction when there are two parents and court-ordered obligations involved. And Judge Bruni's response here is surgical, humorous, yes, but also legally precise. Family court exists precisely because private decisions have public consequences. When custody, parenting time, and child support affect another human being, especially a child, privacy arguments collapse instantly. What we're seeing is a fundamental misunderstanding of jurisdiction. The court isn't involved because it wants to be. It's involved because the law requires oversight when parents don't agree. Sovereign arguments don't override that reality, no matter how confidently they're delivered.
All right, so Mr. Smith, perhaps you should consult a constitutional lawyer This matter is
No, sir.
guided by state law. The court has made a decision.
Sir,
No
it sounds
change of
like you already
circumstances
have
that
a
would warrant a change of
predetermination
custody
of this
attorney
case.
time. And the court will not argue
Sounds like
over
you already
you,
have
Mr. Smith.
predetermined.
So that will
Sir, do
conclude,
you
sir. You
have
can zoom out.
predetermination of this case?
An order will be entered. All right, Mr.
Do
Smith,
you have a
consult an attorney.
predetermination of this case, sir?
This is the Sovereign Citizen Playbook in its purest form. Rapid-fire constitutional references with absolutely no connection to the issue at hand. Notice how none of these citations are tied to custody standards, best interest factors, or statutory requirements. That's because they can't be. Child custody is governed by state law, and no amount of federal buzzwords changes that. What's particularly telling is the shift from legal argument to moral outrage. Claims of enslavement, unlawful money, deprivation of rights. These aren't legal positions. They're emotional reactions framed as constitutional crises. And the judge does exactly what judges are supposed to do here. She redirects, clarifies jurisdiction, and explains, repeatedly, that disagreement with the law does not invalidate the law. Courts don't operate on consent. They operate on authority granted by statute. That's the part sovereign citizens never accept.
How to initiate traffic stops and what to look for.
Okay. Were you on duty on May 24th, 2024 at approximately 9 p.m.?
I was.
What was the weather like at that time?
Weather that day was clear, and it was still light outside.
The road conditions?
Dry.
Okay. And you were on patrol at that time?
I was.
You were in a marked patrol car?
I was.
Where were you on patrol?
I was patrolling the downtown area near 11 Mile in Washington.
That's in the city of Royal Oak?
It is.
What happened at that time at those crossroads?
I was stopped at the 11 Mile and Washington light facing westbound. I had a green arrow and a vehicle proceeded eastbound on 11 Mile through a light, which gained my attention. That light was red for them, which drew my attention to that vehicle.
Okay, what type of vehicle was that?
I believe it was a black 2024 Ford Edge.
Is your vehicle equipped with a dash cam?
It is.
Judge, at this time, I'd like to play that video from Officer Moran's dash cam.
Okay.
This denial isn't arbitrary and it's not punishment, it's procedural. The judge explains exactly why the motion fails. No alleged change in circumstances. That's the legal threshold, and without it, the court literally cannot modify custody. This isn't personal. It's structural. And here's the irony. Had Mr. Smith focused on actual facts, changes in work schedule, living arrangements, the children's needs, he might have had a conversation worth having. Instead, he buried any potentially valid argument under conspiracy language and constitutional misunderstandings. Courts can't rule on vibes. They rule on evidence and legal standards. When you refuse to engage with those standards, denial isn't oppression. It's inevitable.
Is that the video taken from your patrol car?
That is the vehicle for my patrol vehicle.
Does that fairly and accurately portray the events of the incident that led to the defendant being issued a civil infraction on that date and time?
It does.
Your Honor, I'd ask that that video be admitted into evidence.
All right, so admitted.
Officer, so what do you see on that video?
What I see, like I spoke to earlier, I was stopped at the 11 Mile at Washington light facing westbound. I got the green arrow to turn southbound on Washington when a vehicle proceeded eastbound through, obviously, the red light.
And then you pulled that vehicle over?
Yes, I immediately initiated a traffic stop.
And that was on 11 Mile in the city of Royal Oak?
It was, yep.
When you approached that vehicle, did you observe the driver of that vehicle?
I did.
Do you recognize the driver of that vehicle on this Zoom today?
I do.
What's your objection?
Because I was traveling. I wasn't driving.
Now we pivot to the final act, and this one's quieter, but just as devastating for sovereign arguments. Because unlike philosophy debates or constitutional rants, traffic cases live and die on evidence. And evidence doesn't care what you believe. Dashcam footage doesn't care about contracts, consent, or federal jurisdiction fantasies. This is where many sovereign defendants hit a wall. You can talk over a judge. You can filibuster a hearing. But you cannot out-argue video footage showing exactly what happened. And as this formal hearing unfolds, notice the calm, methodical approach by the officer and the court. This isn't drama, it's process. And process is kryptonite to pseudo-legal theories.
Okay, overruled. Go ahead. You can answer the question, Officer Moran.
Yes, I do see the defendant in the court today.
Your Honor, let the record reflect that Officer Moran has identified the defendant, Anthony Mathis.
The record will so reflect.
When you pulled the defendant over, did you have a conversation with him?
I did.
And in that conversation, did he admit to you that he had driven through the red light?
He did.
And ultimately you issued him a ticket?
I did.
What was that ticket for that you had issued him?
I actually issued him an impeding traffic ticket.
Okay. But that's not what he actually did, correct?
No, that's not.
Why did you issue him the impeding traffic ticket?
Mr. Mathis at the time had a good driving record. He knew what he did. He told me he admitted to it, and he had a good attitude on the road. So I chose to go an impeding traffic ticket.
I object.
What's your objection?
I never admitted to anything. Do you guys have that on the record? Did you guys pull that up that I admitted to something?
You'll have a chance to.
That's false.
Mr. Mathis, you'll have a chance. Your objection's overruled. This is his testimony from his memory. You'll have a chance to testify yourself and add any additional evidence here. So at this point, that is not a proper objection. It's overruled. Anything else to add there to that?
What, just very briefly, Judge, what infraction did you actually observe?
I could have wrote him two infractions, either disobey traffic control device or disobey traffic signal.
And that's what he actually did, correct?
Correct.
Judge, I have nothing further at this time.
Now, Mr. Mathis, it's your opportunity to ask Officer Moran any questions that you feel are necessary. Now, I just want to instruct you. You'll have a chance to testify if you choose to in a moment. Right now, anything that you say should be in the form of a question directed at the officer. If you're going to start testifying, I'm going to have to interrupt you and redirect you. You'll have that chance in a moment. It's just to ask questions. So go ahead with any questions you have.
All right. Well, for the record, is there any injured party? Do we have a sworn affidavit or complaint from an injured party?
No, there's no injured party.
Okay, so we don't have any injured party. So Judge, you've been sworn in to uphold the Constitution, correct?
I'm not on the stand. I'm not answering any questions like that, Mr. Moran. Or Mr. Mathis, excuse me.
So what type of court is this? Is this Admiralty Maritime Law?
Mr. Mathis, right now is your opportunity to ask Officer Moran any questions that you want to. If you're going to make some legal objections or something along those lines, you can do that in your closing. But right now, this moment in time is for you to ask Officer Moran any questions.
Okay. Well, for the record, we don't have any injured parties. Correct?
Judge, that's been asked and answered.
Sustained. He already answered that question.
Right, correct. I just wanted to make sure that we got that on the record. So if there's no injured party here, then why are we